Thank you, Chair. I'm Choto Ibrahim, representing people of the Upper West, beyond the district, Musoga Sabri.
Good morning, Chair. Good morning, Chair and members. My name is Najuma Sara, MP Nakaske District. I'm a member of the legal.
Which will follow shortly. Is he as a friend of the committee? But also as a member of parliament. As a member of parliament. Yeah. And the head of the bar. He has come to supervise. He has come to supervise duty.
Attorney General is always, as a matter of standard, witness number one.
Thank you.
Yes.
So can we proceed with the clarification?
We've not introduced ourselves. Good morning, everyone. My name is Kauma Sauda Alibao. I'm the district woman representative for Iganga district, and I'm a member to the
However, as you realize, this whole conversation relates to one issue: trial of civilians in the military courts. That's the only controversy in my view. And I think if we can zero and have a real conversation about that, we might make progress on this. Let us look at what did this case say. 15, you are close 15 of your submission, the Kabaziguruka case. You see, it would be better, because you see there were several judgments. And when you just say the judgment said this, you know, you run the risk, which I see many members of the public, you know, running. This is the judgment, this is the judgment. We need to go to the specifics. Which judge said what on this particular point? Because if you do that, then you narrow the point of interrogation. What did the judgment say? And if we are implementing this judgment, what are the confines? So, as you do realize, many judges had different reasoning, though they came to the same conclusion. And you say the trials of civilians within the military courts, and I'm on page 7, should be only in very limited and exceptional cases. That's what you say. If we can't go just to the judgment itself, because we are going to interrogate those judgments and say, this is what exactly the judges say, or this particular judge said this on this. It will help us, other than having a general conversation, trial, civilians, trial. Number 2, I want you to help clarify on the principle of aiding and abetting. Assuming a soldier has committed a service offense under the UPDF Act, but has been aided and abetted by a civilian. Because the general principle you and me know about, if somebody aids and abets, is equally guilty like the principal offender. Do we have them tried parallel? The soldier being tried, if he has committed an offense under the what? The UPDF Act. Tried in the court martial, then this civilian who has aided and abetted goes to the civilian court. Do you have 2 parallel systems trying a person or different person on the set of the same facts? Third, I think. and I'm glad that Attorney General is here. He should consume this. He's not appearing, but he should consume it. There is a suggestion made by Jude in his presentation that other than using the word in consultation with the Judicial Service Commission, can we give the Judicial Service Commission some wider role in vetting the nominees by the High Command for this position? So that, because since we have not defined this consultation, what does it mean under the law? But if the High Command forwards the nominees to the Judicial Service Commission and they are interrogated as to their capabilities and appreciation of the law, since they are going to perform judicial functions, other than saying any consultation, I think this is, to me, it is a brilliant idea which we can consume to give the judicial service a more role in appointing judicial officers. And by the way, we need to understand this. It is not about civilians.
Lumu, you have the problem here.
Okay. And I think we need to make this clear, colleagues. The court martial should not be about civilians. Because even soldiers need justice. They need justice. And they should be tried professionally. So we are not here to protect interests of civilians. We are protecting interests of everybody who appears in the court martial. No, this is about the court martial. The court is a different matter. So, if we can, the Attorney General can really think about this and discuss it with his minister to say, can we have a wider role of the Judicial Service Commission other than any consultation? To me, I'm convinced actually that that is the way we should be moving, but we shall discuss it later. About Jamil Mukulu, I think this was well explained yesterday, colleagues. The International Criminal Divisions Court is a specialized court, but under the Rome Statute. And it is set up like it is an act of the ICC. So Jamil Mukulu is not necessarily under our jurisdiction. No. Because he's accused of committing crimes that some of them are not provided for, like genocide. And the genocide is maybe not only in Uganda, but also in Congo, wherever he was operating from. He's being accused of war crimes, wherever he's said to have committed them from. So, the International Criminal Divisions Court is not necessarily one of our courts of judicature, but the Rome Statute provides that if you want to try them, other than them being tried in The Hague, you must do this. That's why, even at High Court level, they sit 3. At High Court level, they sit 3 like the unapparent what? Court. So we need to distinguish that Jamil Mukulu, because I see it every other time it's coming and so on. Mr. Chairman, I think that's all for me.
Thank you, Chair. I'm happy that you made time to be here. On page 5, which is paragraph 8, on the tenure of the court martial. Of course, Jude, as counsel and advocate of High Court, considers what the Constitution says about independence of judiciary, where tenure, security of tenure is very important. Now, you propose 7 years, which ordinarily would be good, but this is a special court. You cannot have a soldier at one rank for 7 years. Well, we are putting it to him. So would you?
You can. It has happened.
Well, then.
Are you saying it is wrong?
Well, so I want to interrogate you further on this. What would the problem be if it were 5 years? What the problem would be, because the other thing we encourage, honorable colleagues, the other thing we encourage here is speedy trial. Okay? So why then prolong the tenure if the intention is actually to have fair but also speedy trial? Again, when we have also provided avenues and opportunity to appeal. Thank you.
Thank you very much for this opportunity. I will not speak much. I have a huge background as to how we got here, because it is a matter that started in 2005 with the siege of the High Court. And that's when we started mooting the idea of having the court-martial off our books. When the Supreme Court made what they call advisory opinions, before I even go to the reasons why and how they got there were different options proposed of bringing the operations of military justice within the context of the judicial functioning in Uganda. One of the proposals made, especially through the lead judgment of the Honorable the Chief Justice, was we could create a division in the High Court, just like we have a division in the High Court that handles corruption and other issues. And the reason was to detach the military from the administration of justice, which is a specialized function, not just on technical grounds, but even under the doctrine of separation of powers. And I missed the Attorney General yesterday. He would have explained to me why, of all the options suggested by the Supreme Court, they opted for what we see here. That's why the Honorable Alternate Chair is talking about, stating what he has just stated. 5 years, 7 years, 3 years, it could even be 10 years. As long as somebody you're calling a judicial or quasi-judicial officer has prospects of redeployment, promotion, punishment, and so on and so forth, you are not creating an independent, impartial court. And to me, that's the crux. It has nothing to do with whether you're trying civilians or military officers in a military court. The nature of the establishment of the military cannot guarantee a fair trial. It cannot be an independent court within the description, within the confines of the Constitution. You cannot talk about security of tenure and you're talking about 5, 7, or even 10 years. Why not 20? The moment the person you're choosing as a judge, quote unquote, is a military officer expected to abide by a certain code, Honorable Chair and Honorable Members, you're wasting time. You're not going to create a court that conforms to the tenets of a fair trial before an impartial and independent tribunal or court, by whatever description. And I want to agree with the MP from Bugwe, my immediate neighbor. I've forgotten his name.
The beauty is that under the rules we refer to members by their constituencies. Yeah, like Busiro, which some people who didn't go to school cannot pronounce. Mr. Chairman, the discussion must go back and I wanted to agree with him to the extent whether somebody is a soldier or not, he is entitled to the same privileges once appearing before a court. It must be independent. The second element relates to this thing of aiding and abetting. And I want to relate it to where they said someone is in illegal possession. Legal versus illegal. I mean, I have a licensed gun and someone has just stolen a gun, how we should handle them. One, this aiding and abetting is a matter that must equally be decided independently. Here you are, you're having somebody, a prosecutor in the army, who decides whether to charge me with that offense. He decides, and he's not independent. You have an office of DPP, and this was touched again by the court, a Director of Public Prosecutions, whose function, among others, is to avoid abuse of judicial process. But supposing I am NUP, and this particular officer is inclined to think I must support NRM, as you know how they treat themselves. They feel they are part of the NRM. This officer will charge me with aiding and abetting. Those are ingredients to be proved. Now, the person who is preferring the charge is not independent, like we created office of DPP, presumably independent. Two, the court before which I am appearing is equally not independent, because the judge or judges, whatever their description, expect promotion, expect deployment, supposing he makes a wrong judgment and is posted in Karamoja. So, the Karamoja I'm referring to is where they are saying go into cattle wrestling, and I do not want to impute bad motives on what happens in Karamoja there when you are deployed there. So my view, Chairman, is as we pursue the area of discussion with the government, which I'm amenable to, we must also interrogate why we cannot go for the other options suggested by the Supreme Court, as opposed to this one, because this one is going to take us back into the same conundrum. I want to thank you, sir. Thank you. Finally, Honorable Jonathan.
Thank you, Chair. I have an A on person subject to military law clearly disregards and departs from the reasoning, decision, and directives of the Supreme Court. Can you help us, from your knowledge of the law, of these three parameters, reasoning, decision, and directives, which one ranks higher, if you are ranking? Yeah, just from your knowledge and experience of the three, which one it's more fine? And then, I want also to pick your mind on this. My understanding of the law is that there is an offense of murder or aggravated robbery. That is the offense. And the ingredients which are not provided in this act remain the same. If I can recall, death unlawfully caused with malice and etc. So both the military court and the civilian courts, if you are trying the offense of murder or aggravated, you use the same standard. Under our laws, Article 21 or something, every person must be treated equally. Can you help me marry the equality before the law? When now you decide to send one for the same offense, because it's murder, what the act, what the bill is trying to propose is to create different ways of committing murder. That's what I understand. But the end result is that you have committed the offense of murder. With this one, they're saying, because you use a gun that was not licensed, That's why we are taking you here. With the other one, they are saying because you use a gun which was licensed, that's where you are going to civilian court. Does that speak to that provision of the Constitution of equality before the law? And then I have heard that there are scholars who have done some studies on military justice and something. I want to use the one I know. In Uganda, there appears to be provision for Sharia law, okay, which is not being enforced. My presumption was for the military justice system to work, there must be two legal regimes. The whole set of either the Constitution running with all the supportive acts of what we call military law, and then a whole set from the Constitution flowing of what we call civilian law. So for you to take civilians to cross into this rim, you must have two justice systems. Now, I thought the basis of a military court, if it exists, was that there were a certain set of offenses that can only be committed if you are a military officer. For example, you refuse to attend parade. The general knows others. You refuse to attend parade in the morning. How do you get disciplined? Should we waste your time to take you to a magistrate's court? No. So we deal with you internally under because there is a code, there is a set around that. You are deployed and you abscond from your duty, you go and enjoy other things, and then you are found. So a civilian ordinarily would not be.
Jonathan? So we will proceed. Honorable Councillor Jude, we are giving also, you will be at liberty even to give us another written text. If there are issues that you think you cannot canvass here, we can receive that text tomorrow. Because the House was adjourned for only 1 hour, and at noon we are supposed to reconvene. Yes.
Council has helped us to explain exceptional circumstances, but I'm tussling in my mind to get the explanation of high command as being used in the bill. I'm not getting it. Yet it is subjective to recommendation of the chairpersons and other people to sit on at the division level court. In your own opinion, have you come across the explanation of high command, that terminology, high command? I would like to know. It is confusing me. Where do they get the moral authority to second the legal officers?
This in details, as you recognize, I only had an hour or two to put this together. The High Command is an organ of the Defense Forces and it's provided for in the law. And that's why it's the highest decision-making body in the army, so that should be quite clear. I do agree that there is a legitimate concern, which was slightly beyond the scope of my memo, regarding the separation of the investigative and prosecutorial roles within a justice system. In the military, these two ultimately are fused. And when a person is charged, it becomes very difficult to separate the system, the members of the system who are carrying out the investigation, the members of the system who are prosecuting this individual, and the members of the system who are now performing a judicial role. And that is why it's an area that requires careful thought. But the overall theme, Mr. Chair, which I need to explain, is that all professional armies world over do have court martials. Okay, it's not a unique Ugandan situation, and the purpose why the military system must have a court martial is partly because even these normal offenses like murder may occasionally need input of people who have an experience of combat. For instance, if a soldier is armed and is attacked and kills 20 people, for us the civilians, we may say, no, he has killed 20 people, that's a murder, he has killed them, he must be charged. But the colleagues may say, no, this was self-defense. These people were going to kill him and he had the option to kill them first. So there are contexts like that. For instance, I had I had a view about a police officer who was killed in a mob in Rwanda, and I felt he should have killed more of those people first before he was killed. But you see, those are operational issues. And therefore, there are these crimes which may be committed in the context of, which require some operational insight on what goes on at a front line, in a combat zone. And that is why all modern armies have a level of military courts. Why ours here is becoming controversial is because of, one, this idea of trying to bring in civilians all the time. That's the biggest problem. Then secondly, setting it up as a rival court to the civilian system. It's not, instead of supplementing, it appears to be suppressing the civilian system. Those two are the unique Ugandan issues which we need to look at. One of the honorable members asked why I'm giving the bill 80%. This bill, as I indicated, is way more than this clause about civilians and the military justice system. And like I said in my memo, a large part of it about the welfare of the defense forces is long overdue. I have done work for representing members of the armed forces who are injured, who are amputated, and they are in Mubende, in the hospital, and that is all. And they don't know how to move on with the rest of their lives. So I think it would be very unfair for this bill to get a bad name because of these 4 or 5 clauses which we can work on and which this committee can work on and or remove. The idea about how a military court operates is only getting controversial because of that idea of when you bring in civilians, for us civilians, we look at things, of course, also with the civilian eyes. And the standard of justice we expect and the kind of offenses that are going to be tried makes it very, very critical to comply with a very, very, very stringent standard. That is why in my memo, when I point out, someone gave an example of the offense of murder, you will note, Mr. Chair, that in my memo, I'm insisting that the right of appeal that exists for ordinary murder trials at the High Court, which is 2 appeals, Court of Appeal and the Supreme Court, should be replicated. Because if somebody is tried for murder before the General Court Martial, the bill says they have only 1 right of appeal to the Court of Appeal, and it closes there. That is obviously not fair. Where will be equality before the law will be coming into play, because both people are charged with murder. It can't be that a civilian charged with murder should have 2 appeals, and a soldier charged with murder can only have a right to 1 appeal. It simply creates a system that is not fair. Regarding this subject of explosives,
Jude, how
yes,
do you
please
resonate that with the fact that under the Constitution, one cannot be executed except if there is confirmation by the highest court?
Thank you, Honorable. I did point that out specifically, that a death sentence must be confirmed by the Supreme Court. Yeah. On the subject of explosives, chemicals, and pistols, as I indicated, they are simply listed in a blanket manner as being ordinary monopoly of the defense forces. It is not indicated anywhere in the bill whether there is any other individual who could access them without becoming subject to military law. And therefore that leaves room for interpretation which could be problematic. That applies to explosives generally, it applies to chemicals, and it applies to small firearms, pistols, and that category. The example I gave was if somebody has a firearm and his or her license expires, they are technically holding it now contrary to the law. So if they use it to commit an offense, according to the bill, they will be under clause 117A, will be triggered. They will become subject to military law. And I think that is quite beyond what might be, what the drafters could be having in mind. And that's why I insist about the need to cross-reference the Firearms Act, this law on explosives, and this other one on prohibition of chemicals and toxic chemicals. Because it may not be an issue now, but as I know, honorable members here know this far better than the rest of us, you legislate for the future. You don't only think about the current challenges that we have. We may have more difficult challenges in 5 years, 10 years, over some of these provisions. offenses in the UPDF Act, it's my understanding, Chair, that a specialized court generally should handle offenses from a specialized statute. The moment you have a specialized court and you give it ordinary jurisdiction over the entire criminal justice system, all the offenses under the penal code, you create these challenges that currently exist. Why? For instance, we are talking about the right of appeal. You are charging somebody with murder under the penal code, but the person is being given only one right of appeal. The one who is charged before the High Court is entitled to 2 appeals. The offense of murder, obviously, is one which has to exist in a military court. There is no doubt about it. Court martials world over, members of forces get indicted for the offense of murder in some cases. And the standard has to be who is being covered. And like I emphasize, the problem that we are getting, our discomfort about these provisions largely continues to operate because of how, one, you operate them to civilians. Then secondly, you cannot lock in only one appeal for a person charged within the military justice system. The civilian courts under the Constitution should still have some level of oversight. And that oversight becomes the fair way of letting the court martial handle offenses touching members of the defense forces, but also members of the defense forces are entitled to quality justice, and therefore the civilian oversight should not be disregarded or undermined in that context. The issue of the ICD was handled so...
Councillor Jude, colleagues, I have had the bill. I don't know whether you also had it. And this is the budget. Now, what I have from our side here, we are convinced that Councillor Jude has definitely added value to our process. I request you to give us more time by giving us a text. We will definitely consider the proposals that you have put here and the subsequent addendum that you are going to give us. Now, for now, colleagues, I want to adjourn for plenary. We will resume tomorrow at 9 a.m. Tomorrow is Friday. Okay, House, the committee is adjourned. Sunday. We shall communicate on our next meeting.
We don't need to be ambushed and you call us, someone else on Saturday.
But at least you have had
mbadde ku kakiiko ka Parliamentary kati kweteeka ly'amagye mbadde mbagamba ebintu nga bisatu. Mbagambye nti kooti esalamu emisango ya ssemateeka yonna, Supreme Court mu musango gwa Kabaziguruka yawa guidelines negambe ne bagamba ngu abantu ba bulijjo awitiyita civilians tebasobola kubateeka mu kooti y'amagye except ni wabeerawo conditions ziri very unique. Supreme Court yagamba oba kooti ya bulijjo etalina buyinza kubanga teriiyo. Ati ubwo gendo bangu ngekaramoja ngu judiciary teriiyo tewaliyo kooti yonna. Kati ekyo kisobola kubeera exceptional circumstance. Naye kati mu eno biiru yabataddewo ku teeka ly'amagye etaddemu abantu ba bulijjo bangi clause yonna bagi expandinze. Ate Supreme Court yagamba nti clause eno nedda mugirestricting kubanga exceptional circumstance kitegeeza ki? Kitegeeza ngu si kintu kya bulijjo, si kintu kya bulijjo. Naye kati clause eno 117A eringa ya bulijjo bataddeko oba okola mu magye oli civilian bakuteeka mu kooti y'amagye oba otuula mu barracks bakuteeka mu kooti y'amagye. Byebityo kati ebyo byonna bimenya ssemateeka ate biri in contempt of judgment ya Supreme Court. Kati nze mbadde ntegeeza ba MP baffe nti eyo clause 117A bagijjamu mu biiru, bagijjamu mu biiru kubanga biiru erimu buntu bulungi bya welfare, pension y'amagye, walimu pension, walimu clauses nyingi ziyamba amagye, naye zino clauses zibatadde mu teeka zikwata ku civilians zijja kuleeta obuzibu, zijja kuleeta obuzibu. Ate nebyemundu mbadde mbagamba nti tulina eteeka eribayita Firearms Act likiriza abantu ba bulijjo abalina license kubeera ne za pistol. Ate ndaba mu teeka tebakyogeddeko, tebakyogeddeko ne explosives. Kati wali abantu abakola mining, abakola bya rock blasting, abo babeera na explosives. Ate eteeka ligamba explosives ne pistol, manya uniform, engato, byonna biri ordinary monopoly y'amagye. Kati ebyo byonna abakoze ensobi. Ate tubadde tusaba komiti yaffe ya Parliament ebirabemu ebyo byonna babijjemu basigane ne biiru ennungi eri ku bya welfare by'amagye.
Tuli basanyufu tutandise okufuna abantu ab'enkizo ate abaviirayo ddala n'ensonga ezikwataganira ddala n'ezaffe sina kindi n'okusingawo nga bawakanya biiru eno engeri gyakolebbwamu. Mu byonna twetaaga security of tenure oba okunyweza abalamuzi ku mirimu mu kooti eyo kubanga eyo yennyini y'ensibuko y'obwenkanya. Omulamuzi bw'agenda mu kooti ng'amanyi contract ye ya mwaka gumu oba ya myaka 3 asala emisango ng'olw'okuba ayagala kusanyusa oli azze obujja contract ye. Twetaaga tubanyweze either tubawe ekisanja nga kiwanvu oba tubawe ekisanja nga kikwatagana nga ekyabalamuzi abalala engeri gye balondebwamu kubanga bonna bagenda kusala bwenkanya. Naye nekisingira ddala obukulu kooti eno kibeere very very clear nti abantu balina kugenda kukozesebwayo in very exceptional circumstances oba mu mbeera eteeberekeka ddala n'emisango gyegimu gyegiri mu kooti eza bulijjo ate emisango gyegimu gyegitwalibwa mu kooti martial. Wabeera nga wateekebwayo kooti nga ziri mu kuvuganya ono bwakunyiiza ennyo gwe omutwala eri ono bwatakunyiiza ng'abeera eno. So mu mbeera eyo tusuubira nga bwe twaniriza abantu abalala okujja mu kakiiko kano ensonga zino zigenda kuvaayo bulungi era tugenda kugezaako okukola report eyannamaddala egenda okuteekebwa ku floor of Parliament. Aba veterans bazze nga bagamba nti nabo bafuna ensako ya mitwalo oba 3,300 ya mitwalo 3 buli mwezi nga bagamba nti olw'okubanga balwana ne balwanyisa nakyemalira eyaliko ne baleeta gavumenti eno mu buyinza. Kyembabuuzizza nti oba bagezaako okukola assessment okusinziira ku gavumenti gye bajjako bye yali ekola ne gavumenti eno byeri mu kukola oba bakirowoozaako nti no bajjawo ekyali ekizibu ate nebatuleetera ekizibu ennyo nabwe kityo singa tutandika okubasasulanga obusiimu abantu abeeko baana ne bajjako gavumenti eno kigenda kuleetera abantu abalala bangi nnyo bayingire obuyeekera era nabwe kityo siwagira n'omulundi n'ogumu baveterans okubongeza essente kubanga batuleetera ekizibu.
And then thereafter we'll have our stakeholders introduce themselves, we receive the bill, and then we receive a memoranda from the executive director of IPOD, and we call it a day and we rush to plenary. The rest of the matters can be concluded next week. Patrick, introductions from members.
Mr. Chairman, my name is Medad Segona Rubega, MP of Siro County, Eastern.